In ancient Rome, crimes against the state were considered the gravest offenses, falling under the legal category of crimen majestatis, or treason. Unlike ordinary criminal charges, treason encompassed acts that threatened the sovereignty, dignity, or security of the Roman state or its leaders. The term majestas derives from the Latin majestas populi Romani, referring to the majesty of the Roman people, which meant that harming the state equaled harming the collective authority and identity of Rome itself. The concept of treason in Rome evolved significantly from the Republican period, 509 to 27 BCE, into the imperial era, 27 BCE to 476 CE. Under the Republic, treason trials were relatively rare, as Roman law relied heavily on citizen assemblies, magistrates, and the Senate to maintain political order. During the Empire, however, treason became a frequent instrument of political control, often employed by emperors to suppress dissent, remove rivals, and maintain personal authority. Historical development. In the Republican period, the legal mechanisms addressing treason were not codified under a single law, but were handled through various statutes and senatorial decrees. A key early law was the Lex Julia de Majeste, traditionally attributed to Julius Caesar or Augustus, which formalized prosecutions for offenses that diminished the power of the Roman people or endangered the state. The Republic also relied on the Quaestiones Perpetuae, standing courts established in the late 2nd century BCE for serious crimes, including treason-related matters. With the advent of the imperial system under Augustus, treason law expanded and became more flexible. Crimen majestatis grew to include a wide range of offenses: conspiring against the emperor or attempting assassination, insulting the emperor or his family, acts undermining the dignity or authority of the state, supporting rebellions or foreign enemies, mismanagement of provinces resulting in state losses. This expansive interpretation of treason allowed emperors considerable latitude to prosecute political opponents, sometimes for trivial or fabricated offenses. The historian Tacitus observed that under Tiberius 14 to 37 CE, accusations of treason became a tool of fear, as citizens could be prosecuted for speech, rumors, or correspondence deemed harmful to the emperor's reputation. Legal procedure. Treason trials in Rome followed a complex legal procedure that evolved over time. In the Republican period, the accused could be tried before a popular assembly, a Senate-appointed tribunal, or a special commission. Evidence often relied on witness testimony, documents, and public acts. Defendants were allowed advocates, advocati, to represent them, though political pressure often limited their effectiveness. Under the Empire, treason trials were typically conducted before the Senate or specially appointed commissions. Notably, the emperor or his representatives had the authority to initiate charges, making the process heavily politicized. The steps included: 1. Accusation, delatio. Any citizen could bring a charge of treason against another, delator. The delator sometimes received rewards, including confiscated property of the convicted. This practice encouraged a culture of denunciation, particularly under emperors like Tiberius and Nero. 2. Investigation and preliminary hearing. The Senate or the emperor's officials investigated the accusation. In the imperial era, investigations could involve secret informants and surveillance. 3. Trial, judicium. The accused appeared before a tribunal. In high-profile cases, the Senate itself served as judge. Evidence included witnesses, letters, and testimonies, though trials could be short and biased in favor of the prosecution. Number 4. Verdict and sentencing. Conviction could result in a variety of punishments, including death, confiscation of property, exile, or forced suicide. The punishment often extended to the family of the convicted, especially during the Empire, as a warning to others. Punishments for treason. Punishments for crimen majestatis were severe and intended to serve both retributive and deterrent purposes. Common sentences included death. Executions were carried out by strangulation, beheading, or exposure, depending on the status of the accused. Forced suicide was often preferred for elites, preserving a measure of dignity while eliminating the threat. Confiscation of property. The property of the convicted was frequently seized by the state, which enriched both the treasury and the delators. Exile. Citizens might be banished to distant provinces, effectively removing them from political life. Loss of citizenship. In some cases, Roman citizenship could be revoked, depriving the individual of legal protections and social status. The flexibility and severity of treason punishments allowed emperors to maintain a climate of fear, discouraging dissent and consolidating personal power. Tacitus described how trials under Tiberius often combined public spectacle with intimidation, where witnesses, both willing and coerced, played key roles in securing convictions. Notable cases. Several Roman treason trials illustrate both the political and legal dimensions of crimen maestatis. 1. Scribonius Proculus and Marcus Lepidus, 69 CE. During the year of the four emperors, these senators were accused of plotting against Emperor Vespasian. They were executed swiftly, illustrating the lethal consequences of political opposition in times of instability. 2. Seneca the Younger, 65 CE. Philosopher and advisor to Nero, Seneca was implicated in the Pisonian conspiracy, a plot to assassinate the emperor. Though evidence was largely circumstantial, Seneca was forced to commit suicide, demonstrating how treason law could target intellectuals and advisors under suspicion. 3. Sejanus, 31 CE. Lucius Aelius Sejanus, the ambitious prefect of the Praetorian Guard under Tiberius, was accused of plotting to seize imperial power. His trial before the Senate resulted in execution and posthumous condemnation. The case is notable for its use of informants, confiscation of property, and terror-driven purges of his associates. Political implications. Treason trials were as much political tools as legal proceedings. Under emperors with autocratic tendencies, the law of treason became a mechanism to eliminate rivals, silence critics, and instill fear. Historians like Tacitus and Suetonius emphasize the manipulative use of these trials in consolidating power, noting that the broad definition of maestas allowed for prosecution of seemingly minor offenses. In contrast, during the Republic, treason trials were constrained by legal tradition and political negotiation, reflecting a balance between citizen rights and state security. The transition to the empire highlights the tension between legal norms and imperial authority, a theme that resonates in legal history studies of Roman law. Legacy Roman treason law influenced later legal systems, especially in the development of concepts like lèse majesty in medieval and early modern Europe, where offenses against the sovereign were criminalized. The procedural innovations, such as special commissions, use of informers, and political trials, have been studied by scholars as early forms of state-controlled judicial mechanisms. Moreover, Roman treason trials provide insights into the intersection of law, politics, and social control. They demonstrate how legal frameworks can be adapted to serve political objectives, how fear can enforce loyalty, and how the rights of the accused can be subordinated to state interests. The lessons from Roman treason trials continue to inform discussions on authoritarianism, legal ethics, and human rights. Sources: 1. Balston, JPVD, Roman Law, The Civil and the Criminal, London, Routledge, 1952. 2. Crook, J.A., Law and Life of Rome, Ithaca, Cornell University Press, 1967. 3. Tacitus, Annales, translated by Michael Grant, London, Penguin, 1996. 4. Suetonius, The 12 Caesars, translated by Robert Graves, London, Penguin, 2007. 5. Robinson O.F., The Criminal Law of Ancient Rome, London, Routledge, 1995. 6. Froelich R., Crimen Maestatis, Treason in the Roman Empire, Berlin, De Gruyter, 2003. 7. Southern P., The Roman Empire from Severus to Constantine, London, Routledge, 2001.